Hi, I'm Anna Denton-Jones and I'd like to explain to you a little bit more about settlement agreements before we speak about your own particular circumstances. Settlement agreements are not unusual and can be used in any circumstance where an employee's employment is coming to an end. Typically, the employer wants to enter into the agreement so that they have the certainty of knowing that once you've signed, once they've paid you some money, that there is no comeback from you, so you're not going to bring any form of employment tribunal claim. So that's the prime reason why the employer will perhaps want this document. The secondary reasons that an employer might want the document may be to gag you and make you keep the fact that you've had some kind of a package from them a secret, perhaps from other colleagues, so that other people can't argue that there's been some kind of precedent set for the future. So there may be issues around confidentiality. The settlement agreement itself is governed by some legislation. That legislation sets out that you have to have independent legal advice on the document, which is where I come in, and it also dictates that certain ingredients go into the documents. There are certain clauses that you will see within it, listing out a long list of legislation, for example, setting out that I've got insurance and all those sorts of things. Those clauses will be ingredients that are in there because it's a requirement of the legislation. Because the documents are drafted typically by the employer, by their solicitors, they do tend to be quite one-sided documents. They're protecting their interests at the end of the day. So my job is to help you perhaps try and make the document less one-sided as we go through it. In terms of the things that I'm looking for, I'm going to be checking whether or not the particular termination date that the employer is proposing makes sense for your particular circumstances. I'm going to be looking at whether there is anything unusual in the document. Is there anything out of the ordinary that I need to draw your attention to? I'm going to want to understand, obviously, everything that you're entitled to as part of your normal package when you're working for your employer. So not only your salary, but also the other bits and pieces that you might have, like pension or various insurance policies, because I'm going to want to make sure that you are being adequately compensated, and that you are receiving all the entitlements that you are due before you enter into this. I'm going to also want to know the background as to what's happened to you, so I can assess the extent to which you may have claims that you would be giving up as part of this arrangement, so that I can give you further advice on that. I'm also going to be picking up on things like whether there's a reference being provided for you, whether any oral comments about you will be given in the same spirit as the reference, whether what you can say to third parties about why you're leaving, because that's going to be very important to you as you move forward and try and find alternative employment. You know, what can you say? We don't want the gagging clauses to be so strict that you're unable to talk about, for example, the fact that there's a redundancy situation. And I'm going to be thinking about the tax implications of the payments that are being made to you. Sometimes employers do get that wrong and they propose paying some tax-free when actually they can't. So I'm going to need to see your contract of employment so that I can help you with that. The other reason for showing me your contract of employment is I can then also advise you on the restrictions that might be applicable to you after you leave your employer. The document itself doesn't become binding until it is signed by both parties. So whilst we're in a period of negotiation and discussion over that document, you do need to maintain confidentiality. You don't want to do anything that's going to get you into trouble with your employer. Even if the proposal is that you are leaving, you know, up until we have signed that document, you are still an employee. You've got a duty of fidelity to your employer, so you're not free to take up employment somewhere else quite yet. What are some of the common things that go into a settlement agreement? We've talked about tax. There may be a tax indemnity provision in there. If the employer is paying you some money tax-free, they're likely to want you to promise that if HMRC did go after them for taxation, saying that the company had got it wrong or the organisation had got it wrong, they'd want the ability to come after you then if that happened. I'll want to check that the wording of that isn't too broad or unreasonably worded, and I can advise you on the likelihood of that happening in your particular circumstances. There's likely to be provisions around the return of property, so you may have things that you need to return to your employer. They may well want you to delete documentation and things that you might have on home computers that relate to them, and you might have property of your own that we need to think about you getting back. Your employer might want you to promise to provide them with assistance in the future. So if there was some kind of health and safety investigation or something after you'd left, that you would go back and cooperate as part of that. Practical reality is you can probably be witness summoned if it was a court case anyway, and if you would say to me in the last 15 years or so, how many times can you remember this clause actually being invoked, I'd have to say to you that it's infrequently done. We've already talked about confidentiality. There might be gagging clauses that restrict what you can say. You may not be entitled to make derogatory comments about your employer. You might want to make that a mutual promise so that your employer can't make any derogatory comments about you either. The guts of the settlement agreement, or the most important part of it from the employer's perspective, is this idea of drawing a line in the sand between the parties, that you won't bring any complaints, so you're likely to be signing away the ability to bring any contractual claims, the right to bring any unfair dismissal claims, the right to bring any discrimination claims. In fact, your employer may have listed every employment law claim they can think of and sort of added the kitchen sink in for good measure. I'm going to be making sure that certain things are not included on that list. So obviously once you've signed the settlement agreement itself, it becomes a contract that you can then enforce against the organisation if they, for example, didn't pay you. They are not entitled to make you sign away claims in relation to your pension pot, for example. The same would be true of statutory maternity pay claims. In respect of personal injury, you may well be in a position where you're asked to sign away any claims relating to things that have happened to you prior to the settlement agreement arising or being signed, but not signing away claims in the future. So if, for example, you found out, there was asbestos in the ceiling and you became well in the future, we don't know about that at the date you sign the document, therefore you can't give that up. But if you've hurt your knee this week, walking down the stairs or across the car park, then you know about that. You would be signing that away. So obviously if there were any issues around personal injury, I'd need to know and we'd need to talk about it. There's also likely to be something called warranties in your document. A warranty is another word for a promise. So you're likely to be asked to promise that you haven't, for example, committed gross misconduct or done something that would justify the employer dismissing you without any payment. You're likely to be promising that you haven't got another job lined up, because again, the employer's not going to want to pay you money if you're just going to walk into another job and mitigate your losses. You might have to promise that you're not aware of any personal injuries, or that you haven't already breached the terms of this agreement, so confidentiality being really important there, or you've already gone to ACAS or the Employment Tribunal with a claim. There's likely to be something called an entire agreement clause in the document, which is essentially a way of saying everything that we agree is in this document. So if you've been made promises by a line manager about something in particular, we need to know and make sure it's in the document to protect your interests in that regard. And then finally, legal fees. It's quite typical for the employer to pay the legal fees of the employee. Typically employers don't offer enough of a contribution here, so again that might be something that I end up in a bit of an argument with your employer about on your behalf. Sometimes if there's a long gap between signing of the document and when you would actually be leaving, perhaps if you've got a long notice period, the employer may well want you to sign a second copy of the document at a later stage to confirm that no claims have arisen between the date on which we first sign it and the final date when you leave. I'm looking forward to going through your particular settlement agreement with you. Please do contact me once you've had an opportunity to digest this.